I am at the Ryan E. Murphy Law Firm, and I have Ryan Murphy with me. Good to see you again.
Good to see you.
All right, I want to talk about something. This has got to be in the back of probably anyone's mind, especially as we get older. If you're injured on the job, and it's to the extent that you cannot return to employment, what kind of benefits, what do you have in your favor?
That is something that we have to deal with on a regular basis. It's a specific type of benefit that someone receives under Missouri Work Comp Law called permanent total disability.
Okay.
And it arises when the person is unable to maintain employment because of the work injury that they've had. Mm-hmm. And what they get is the law provides benefits in the form of a weekly check for the remainder of their life.
Really?
Yes, and they get that because the work injury or the work injury combined with some pre-existing injuries prevents them from maintaining any employment from then on. And so people still have financial responsibilities.
Yes.
People have a mortgage, people have car payments, people have dependents that rely upon them. And if they're not able to work because of a work accident, these benefits kick in and allow them to support, pay their bills, support the people that depend on them under the Missouri law.
This sounds rather subjective. What might keep you from working may not keep me from working, so this is a perfect reason that you have to seek out an attorney.
That's exactly right. It's based upon a bunch of different factors, and so these are complicated cases. You need a good attorney.
All right, here's a good attorney right here, Ryan Murphy at the Ryan E. Murphy Law Firm. Give him a call. I am with Ryan Murphy, and I am at the Ryan E. Murphy Law Firm. Good to see you again.
Good to see you.
Okay, I want to throw kind of a scenario out to you. I'm a worker. I've been injured on the job. Now I'm under medical care. I've got a manager who's trying to push. Now the doctor has told me, here are the guidelines. You can't go out of this restricted area, but my manager wants me to do a little more. Do I have any remedy? Do I have any recourse at all?
Yeah, absolutely. That's one of the more common issues that arises, and actually one of the easiest issues to resolve.
Okay.
Oftentimes, managers who have their own pressure, their own production numbers that need to get met, will gently pressure, or sometimes not gently pressure, an employee that's been injured and is under medical restrictions to work outside of those restrictions. Mm-hmm. And that issue resolves itself very easily because that not only does that employee not want to get hurt further, but if he is hurt further, it's the employer that is in fact responsible for those further injuries. And so those medical restrictions, they're not there to inconvenience the manager or the injured employee. They're there to keep the person safe. And that's a doctor with their medical expertise saying, if you work outside of those restrictions, you're likely to get hurt further.
So this doesn't seem like it's necessarily adversarial. This can be kind of actually a win-win situation for everyone involved.
Well, it certainly is a situation where it is keeping the person safe, okay, and allowing them to heal from the work injury.
If people want more information about this or other workers' comp questions they might have, how do they get it?
Well, they can either go to our website, they can call our office, or they can make an appointment with me and we can talk personally.
All right. Ryan E. Murphy Law Firm. I'm with Ryan Murphy at the Ryan E. Murphy Law Firm. Good to see you once again. We're going to talk about something that scares everybody. It's a phrase called pre-existing condition. It also happens in workers' comp cases because sometimes you'll get an injury on the job, yet your employer claims it's due to a pre-existing condition. What can you do?
Well, this is one of the most common avoidance techniques that the workers' compensation insurers might use to avoid paying on a work comp claim for an accident and injury that happened at work. And what happens is they say, well, this is due to degeneration or something along those lines.
Sure.
And my client will go to me and say, look, I've never had any problems whatsoever. I didn't have any pain whatsoever. And the way that we solve that is by getting into the medical evidence, okay?
All right.
The employer is only responsible for the injury caused by the accident, and that's what we want them to be responsible for.
True.
And so what we do is we get into the pre-existing medical records, if any exists, or if none exists, we go and get a medical opinion from a doctor after the accident to determine what injury was caused by the accident versus what was there before. And we're able to differentiate between the two.
Is it a neutral medical opinion?
Yeah, it's called an independent medical evaluation. That's exactly right. So what we do is we make sure that the employer and their workers' compensation carrier are responsible for the injury caused by the accident,
Because that's what it's about.
because that's what workers' compensation benefits is about.
All right, people want more information about the benefits that they deserve. How do they get it?
Well, they can either call our office, they can go to our website, or they can make an appointment and talk to me personally.
All right, Ryan Murphy at the Ryan E. Murphy Law Firm. I'm at the Ryan E. Murphy Law Firm, and I am with Ryan Murphy himself. Good to see you again. All right, let's set up a scenario here with workers' comp. I've been injured. I've been under care. Now the doctor, the workers' comp doctor, has said, you're fine. You can go back to work, yet I still feel lousy. Do I have any recourse here?
Yes, you do. This is something that happens from time to time. It's not horribly common, but it really does happen. And when it does, it can be incredibly frustrating for the injured employee. And what we do, really, we gather all the relevant medical records, and then we have our client examined by a doctor that we choose, who is not a part of the work comp system from an insurer's standpoint. And so the doctor that we choose reviews all these relevant medical records, examines my client, and then issues an opinion that it really goes in one of two directions. There is nothing more that can be done. You know, what this person has is what they get. And that has the benefit of the person being able to sleep well, knowing that everything that can be done medically has been done to get them as good as possible.
Right.
Or the other scenario is, hey, something more can be done to make this person better. In which case, the doctor will issue a report, and it'll be him saying, hey, to a reasonable degree of medical certainty, based upon my expertise, review of the records, review of this patient, more can be done, and then we can take that evidence to the judge and hopefully convince the judge to get this person more treatment.
So you're not out in the cold.
That's exactly right. There is something you can do.
All right, there is something you can do. Give him a call at the Ryan E. Murphy Law Firm. I am with Ryan Murphy, and we are at the Ryan E. Murphy Law Firm. Good to see you once again.
Good to see you.
Okay, this is one that drives people crazy. You've been injured at work. The workers' comp doctor says you need this treatment, and yet your company says you ain't gonna get it. What can I do?
Yeah, this is a big pet peeve of mine. Oftentimes, it's not the company saying you're not going to get it, it's their work comp insurance carrier. The insurance company just doesn't want to pay for it. And it is something that I'm able to resolve relatively easily with court intervention. It's generally something that an individual is not going to be able to do on their own and will require a lawyer to get the courts involved.
I would think so.
Because in this particular case, when the insurance company chooses a doctor, they have a legal obligation to follow that doctor's recommendations and provide the medical treatment that the doctor that they chose recommends. But sometimes, usually because it's costly, they just don't want to do it and refuse to authorize it.
Well, how can they say, we're choosing this doctor, but we're not going to listen to this doctor?
Legally, they can't. And that's why we have to get the courts involved sometimes. And that's exactly what a lawyer does. He knows the process to file the appropriate claim ask for the appropriate hearings, present the evidence in an appropriate manner so a judge can make the right ruling under the law and my clients get the treatment that they need and deserve under the law.
It sounds to me, rather than get frustrated, get a lawyer.
That's exactly right.
How do they get more info?
They can go to our website, they can call us, or they can meet with me personally.
Ryan Murphy. I'm with Ryan Murphy, and I am at the Ryan E. Murphy Law Firm. Good to see you again, Ryan.
Good to see you too.
All right, person is injured at the job. However, because they don't report it right away, their employer says, well, you're not entitled to workers' compensation. You have to report it in 24 hours. What's the deal?
Strangely, we see that a lot, and it might be a company policy. Hey, you need to report all injuries within 24 hours, but that is 100% not the law. It is what lawyers call black letter law, meaning
Okay.
crystal clear, not even up for debate, that an employee has 30 days to report an accident and injury at work to his employer and be entitled to 100% full workers' compensation benefits.
So that is etched in stone, 30 days.
It's really not even up for debate, but so many employers have a policy that they would like someone to report an injury within 24 hours. Well, a lot of times that's not feasible. People are very often not able to assess whether they've actually sustained a serious injury or just a small little strain that goes away once they go home and rest up for the evening.
Yeah.
And
yeah.
so the law is clear. You have 30 days to report a work injury. The employer's policy, whether it be 24 hours, 7 days, whatnot, in no way precludes a person from receiving work comp benefits.
Law supersedes any kind of company policy in that case.
Correct.
If people want more information about this or so many other topics related to workers' comp, how can they find this from you?
Well, we have a great website with tons of information available for individuals. They can always call our office and make an appointment. I enjoy meeting with potential new clients who want to get their questions answered.
All right, give them a call. The Ryan E. Murphy Law Firm.